discussed. Our session will be dedicated to refusal of supply in the sectors of pharmaceuticals and medical devices. The linking element between the two presentations you are about to listen from my colleagues is restrictions on parallel trade. Restrictions on parallel trade is considered a classic topic of competition law. However, it still raises complex questions. In this session, we will delve into the particularities of healthcare industries and share our insights from the application of well-established EU case law in the Greek jurisdiction. At present, there is a hot discussion among competition law practitioners on the Commission's draft guidelines on Article 102 of the treaty. There seems to be criticism regarding a shift from an effect-based approach to a more formalistic one with respect to the assessment of abuse of dominance. Regrettably, in Greek jurisdiction, civil courts have always had the tendency of a rather formalistic application of Article 102, as well as of the respective Article 2 of the Domestic Law 3959 of 2011, especially in terms of refusal of supply. Our first speaker, Ms. Angeliki Rousaki, Senior Associate at Calavros Law Firm and Head of our offices in Thessaloniki, will share insights in relation to the controversial definition of ordinary orders in determining the substantiation of abuse of dominance under Article 102 of the treaty in the pharmaceutical sector. Angeliki will explain how national courts have applied the LELOS criteria and the conflicting approaches adopted by the Greek administrative courts on the one hand and civil courts on the other hand on this specific matter. Now, please allow me a short comment before I move forward. I want to say that our team here is particularly happy to discuss this topic today for one more reason. Our law firm was involved in the litigation that led to the issuance of the LELOS ruling from day one. We started back in 2000 by defending a vast number of concurrent petitions for interim measures that were brought by wholesalers against our client before the Greek national courts and the Hellenic Competition Commission, all the way to the court in Luxembourg and then back again to the national courts. Not to mention that this bumpy, if I may, journey was made twice and still has not come to an end. Angeliki will share with us further details on this and hopefully we may draw certain conclusions. Our second speaker, Ms. Iris Dolapsi, Senior Associate at Calavros Law Firm, will address the issue of refusal of supply in the sector of medical devices and in particular in the aftermarkets. In light of recent case law, Iris will discuss the market definition, which plays a pivotal role in determining an OEM's right to refuse supply in the downstream market. Iris will also discuss the delicate matter of the distinction between refusal of supply when it is, as a unilateral act, when it is conducted by a single economic entity, as opposed to the assessment of refusal of supply when it is considered as a result of an anti-competitive agreement. It turns out that the existence of restrictions on parallel trade may be decisive in this case. Iris will share with us further details on this. Now, Angeliki, when it comes to refusal of supply of pharmaceuticals in relation to parallel trade, are there any particularities as compared to other commercial goods?
Thank you, Anna. Well, as a lawyer, my genuine reaction would be, it depends, as regards the question posed. Nevertheless, I hope that by the end of this presentation, we will be at a position to draw specific conclusions. As a sort of disclaimer at this point, I would like to share that our firm has a particular focus on the pharma sector. We consistently advise major multinational pharma companies inter alia on competition law matters. So I need to warn you that there might be a slight inherent bias in my presentation in favor of pharma companies. However, please rest assured that it's still well established in case law, both EU and domestic. So as the clock is ticking, and there are quite few things to discuss, I will move forward. It is common ground that under the EU law, parallel trade is deemed a key contributor in achieving single market integration. Any practice that leads to a partitioning of the single market is deemed by the Court of Justice to run counter to this key objective of elimination of national barriers. Recently, the Commission once again confirmed that any abusive refusal of supply which aims at the restriction of parallel trade is a per se violation of Article 102. I speak of Mondelez case. In particular, the Commission speaks of Mondelez's refusal to meet ordinary orders of a broker in Germany to prevent the resale of such products to other countries where Mondelez held a dominant position and the prices were set higher. The Commission, as already mentioned, found by object violation of Article 102 of the treaty. It confirmed that an objective justification or an efficiency defense is always an available escape from this objective, by object violation. Well, the recent Mondelez case had to do with refusal of supply aiming at restrictions of parallel trade of chocolate tubs. The example is not randomly selected to the extent that the Commission relied heavily on the LELOS precedent in order to establish an infringement. So one still wonders, does the pharma sector present any particularities when it comes to refusals of supply aiming at the any restrictions of parallel trade? This is our topic that will be discussed hereafter. Well, it is well known that the key driving factor of parallel trade is specifically of medicinal products. It is the price difference among member states. However, such price difference reflects, in fact, different state policies in healthcare sector. To this end, initially, it had been argued that parallel trade of medicines does not actually contribute to the single market integration to the extent that it is the states and not the private entities who fix the prices. In Greece, the prices of on-patent medicinal products are set as the average of the lowest ex-factory prices. It comes thus as no surprise that it has traditionally been a really popular source member state for parallel exports. For parallel exports of on-patent medicines where, to other member states where the prices are set higher or perhaps have a regulatory framework favoring parallel trade. Against this backdrop, I will continue my presentation with a story which is somehow deemed a classic in competition law. As mentioned earlier by Joanna, our law firm had the privilege and honor to be involved from day one to the multifaceted litigation which led to the issuance of the LELOS ruling. We do not intend, of course, to revisit the LELOS case per se, but mainly we wish to share our insights and try to shed some lights On the application of the criteria set by the court in determining when refusal of supply as a measure to restrict parallel trade in pharmaceutical sector is justified in terms of abuse of dominance. It must be underscored from the outset that this question is far from being settled, at least by Greek courts, which had originally referred for a preliminary ruling. This fact may not come as a surprise if one recalls that the Lelos ruling back in 2008 was considered a great victory, both from the pharma sector and the wholesaler standpoint. So very briefly, the factual background of the case may be summarized as follows. Back in the late 90s and early zeros, the Greek affiliate of a major multinational pharmaceutical group company found itself selling 4 times the national prescription requirements of Greece. With regard to 3 then considered a star on patent medicinal products. The greatest part of such quantities were channeled for parallel export around EU member states where the prices were higher. The situation led to shortages in the source member state, as well as it jeopardized the business interest of the pharma group. After a period of endeavoring to meet the enormous orders placed, the undertaking's response was to halt supplies for a period of about 9 weeks to all intermediaries. Subsequently, after the relative normalization of the situation, it resumed supplies, applying, however, certain quota schemes. This factual background triggered a litigation, still ongoing, before national courts and the Hellenic Competition Commission. This litigation gave us on EU level 2 landmark decisions, the CFAIT and the LELOS. The CFAIT offered guidance in procedural terms, as well as really enlightening opinion delivered by the Advocate General Jacobs. The LELOS ruling, on the other side, addressed the intriguing question of how to reconcile the business interests of the pharma companies, the business interests of the wholesalers for the continuation of lucrative parallel trade. From the other side, we have the safeguard of the smooth supply of each local market, and of course, the dominant undertaking's duty to be fair and treat equally all its customers. Well, one can tell from the outset that this was far from an easy task to handle. It is well known that the Court of Luxembourg found that, in principle, a dominant pharma undertaking cannot restrict parallel trade in whole. This would be a per se abuse of dominance. However, a dominant undertaking is still entitled to take proportionate measures in order to safeguard its business interests. To this end, the court found that the pharma company would only abuse its dominance if it refused to meet ordinary orders. Such ordinary orders are to be determined by the application of 2 criteria: prior business relations and national demand criterion. In practice, the correlation of these 2 criteria proved to be a rather hard exercise, provoking instant uncertainty and unpredictability to all market players. During the period spanning from 2009 to 2014, the national court's initial response to the matter was really poor. At first, the Administrative Court of Appeals in Athens, as well as the Supreme Court, when called to rule upon the case, found that crucial for determining which orders qualify as ordinary was only the prior business relations criterion, without applying at all the national demand criterion. This resulted in fact, in a vicious cycle and did not respect the reasoning of the LELOS ruling as a whole. In particular, what it was observed was the segmentation of certain parts of the LELOS ruling, which praised the value of parallel trade in achieving single market integration, while turning a blind eye to the question of the effective application of the national demand criterion, without at the same time leading to an absolute restriction of parallel trade. All in all, the national courts, in their first attempts to interpret the notion of ordinary orders, resorted to safer places, older precedents such as the United Brands, where, however, the national demand criterion was totally absent, not to mention that had nothing to do with the pharma sector. Furthermore, what the national courts failed to consider was the key fact that the previous status quo of orders placed did not, by wholesalers back then, did not reflect a normal and viable solution. The period of the time preceding the halt of supply back then was marked by frenetic parallel trade activities. Specifically, in the case then in Greece, the quantities of the orders placed were enormous, being naturally out of all proportions as regards the national demand requirements. However, the initial response of national courts was totally to disregard this criterion. The first, let's say, earnest attempt to apply the so-called LELOS criteria was only made in 2018 by the Hellenic Competition Commission. Indeed, the HCC, ruling on remand, albeit found abused to a certain extent, at least made a serious endeavor in finding a formula reconciling both criteria, honoring at the same time the reasoning of the preliminary ruling as a whole. The HCC opted for a distinction between wholesalers active primarily in the local market, who also channeled a relatively small part for exports, and major wholesalers who destined the ordered quantities primarily for parallel exports. In brief, the HCC held that the pharma company abused its dominance by refusing to meet in whole the orders placed by wholesalers who met primarily the local market demand, while also channeling a relatively small part in parallel trade. On the contrary, it found that the same conduct, the refusal of supply, was not abusive vis-à-vis the wholesalers who destined the major part of the ordered quantities for parallel exports to other member states. This approach, albeit reasonable to a certain extent, insofar it factored in the national demand criterion, it still presents the major handicap of lack of predictability and uncertainty from the side of the dominant undertaking. This is because it is always practically called to confirm whether the ordered quantities are destined for meeting local market needs or for parallel exports. Despite this handicap, the HCC was the first authority to factor in the national demand criterion, which was totally disregarded up to then. The HCC decision was upheld to the extent that it found infringement. To date, the case is still pending before the Council of State with regard to the validity of the decision, insofar it found that the conduct was justified on the basis of out of ordinary finding. It is notable, however, that the Council of State, when ruling on the petition for cassation of the pharma company, in the form of an obiter dictum, held that, in any case, EU law does not prohibit the EU member state judge from finding abuse which may not be that certain practice or conduct is abusive under EU law. I'm sorry, while not abusive under EU law, it still may be abusive under the domestic law. This means that it is the Council of State implied that it's not strictly bound to apply the LELOS criteria in order to adjudicate the case under the mirror Greek provision on abuse of dominance, leaving thus room for deviated approaches and interpretation of the same conduct. Well, this approach is of course questionable in terms of EU law, however, it falls outside of the scope of this presentation. On the other end of the spectrum, the same litigation is still pending before the civil courts in the context of claims in tort for abuse of dominance by major wholesalers who, according to the HCC's finding, channeled the major part of the ordered quantities for parallel exports. Surprisingly, the Court of Appeals in Athens in 2020, following the HCC decision, once again disregarded fully the national demand criterion and held that the undertaking's conduct was abusive, assessing only the prior business relations. It is noteworthy that the Court of Appeals held that the fact that it was indisputably established that the particular wholesaler was destined over 80% of the ordered quantities for parallel trade was totally irrelevant. Interestingly, the court held that the wholesaler traditionally destined the major part of the quantities on exports, forming somehow part of parties' ordinary business, course of business. Actually, the court seemed to adopt a pragmatic interpretation of ordinary orders. However, such reasoning runs counter to the LELOS ruling, seen again as a whole. This decision confirmed once again the vicious cycle referred to earlier, because under this scenario, a dominant company had to continue supplying enormous quantities in order to facilitate parallel trade of certain wholesalers. Well, if not in perpetuity, at least as long as there would be interest from the wholesaler's perspective. I guess until the expiration of the patent. However, this kind of reasoning, as already mentioned, runs counter to the LELOS ruling insofar as disregards the national demand criterion as well as the legitimate business interests of the farm undertaking. The said Court of Appeals decision was recently quashed. In particular, in the end of 2023, the Supreme Court, departing from its previous case law, held that in assessing whether a dominant pharmaceutical company's refusal to partially supply a wholesaler's orders on a certain medicinal product constitutes abuse of dominance, it must determine when such orders were in line with the local prescription needs in light of parties' previous business relations. This dictum clearly echoes paragraphs 71 to 76 of the LELOS ruling. Ordinary orders that the dominant undertaking must meet are those which are in line with parties' prior business relations seen in light of the national demand. In other words, the quantities that the dominant undertaking used to supply to the certain wholesalers in order for this particular wholesaler to meet the local needs. This welcome interpretation employed by the Supreme Court shifts emphasis from the prior business relations criterion to the objective national demand criterion. In doing so, it seems that the Supreme Court establishes an effect-based approach of interpreting Article 102 when it comes to refusals of supply. After this roller coaster of the case law, it remains to be seen whether the Council of State will align with the Supreme Court's interpretation so as to avoid a potential deadlock. However, from the preceding analysis, it became, I think, abundantly clear that it all boils down to the effective application of the national demand criterion. It seems that the national courts premised on the unequivocal significance of parallel trade as a key contributor in achieving market integration somehow found hard to consider and factor in the element of local demand in the equation. And I think that it is totally understandable, because it is hard to find this thin line of allowing a moderate parallel trade while safeguarding the local supply and permitting an out-of-control parallel trade of medicines. Comparing case law produced generally on restrictions on parallel trade seen as abuse of dominance with the Lelos ruling, which is unique as regards the pharma sector, it seems that limitation of parallel trade to partial refusal of supply is justified to a certain extent, deviating, let's say, from the rule of thumb. The reasons informing this deviation seems to be at least threefold. First, the high degree of regulation of the market, especially in terms of price fixing by states. Second, the limited benefit for consumers, after all, from parallel trade on patent medicinal products, which is still, to a great extent, kept by the intermediaries. And third, the factor of the need of instant availability of medicinal products in the member states, given that parallel trade is often pinpointed as a cause of shortages in the origin state. Finally, although no causal link has been formally identified, I believe that safeguarding producers' incentive to R&D plays always a pivotal role in balancing the conflicting interests when it comes to restrictions of parallel trade through partial refusal of supply. So, I hope that my presentation does not ultimately leave us with more questions than answers.
Well, thank you, Gilki. So, I understand that after the lapse of more than 16 years following the issuance of Lelos, the very same litigation that triggered the preliminary ruling is still ongoing, leaving room for conflicting interpretations. Now, coming back to the original question, would it be correct to conclude that it is the national demand criterion that distinguishes the pharma sector from other industries?
Well, I think yes, after all. For example, as I said earlier, in the recent Mondelez case, although the Commission relied heavily on the Lelos precedent in order to establish a by-object restriction, it did not factor in the element of national demand in determining whether the orders placed were ordinary. In particular, very briefly, the decision speaks of explains why certain certain orders on residual products were deemed ordinary, without any reference, of course, to local demand. At the same time, a subtle allegation that the certain broker there would export like crazy around EU member states, not only did not play any role in finding that certain orders were out of ordinary, but on the contrary, it reinforced the statement that there was an intention, or that the refusal of supply was with the intent of restricting parallel trade. So yes, I think one can tell that it is the national demand criterion that ultimately deviates the pharma sector from other commercial goods.
From the evolution of case law on the matter, I understand that the issue is still debatable. I think that this controversy stems from the LELO's ruling itself. It seems like the Court of Justice, in its attempt to maintain the delicate balance between ensuring market integration and the business interests of pharma companies, which must remain being motivated to innovate, came to a somehow halfway solution, passing the ball to the national courts. And then again, the national courts seem to find it hard to decode the ruling.
This is exactly the issue. As I noted during my presentation, both pharma companies and wholesalers claimed victory when it came to the issuance of the LELO's decision. So there is an inherent controversy in this decision and the certain criteria that it established for the determination of which orders are to be qualified as ordinary. Having myself defended the case as co-counsel before domestic courts, I can confirm firsthand that it is a really, the out of ordinary defense proves to be a really thorny exercise in practice. However, the adopted approach the approach adopted by the Greek Supreme Court and earlier by the Hellenic Competition Commission seems to be the only viable solution when it comes to the correlation of these two criteria and their application in practice, honoring at the same time the preliminary ruling.
Thank you. Thank you, Gilgi. Now, let's turn to our second speaker. Iris, from the standpoint of medical devices, please share with us your insights. Are there any particularities similar to the pharmaceuticals when it comes to refusal of supply?
Thank you, Ioanna. Good afternoon, everybody. We will now address the refusal of supply of medical devices from the aftermarket's perspective. In particular, we will explore whether an original equipment manufacturer of medical devices, an OEM, as Ioanna explicitly stated, is entitled or not to refuse the supply of spare parts to third-party independent service providers in light of the EU competition law. Of course, we all know that the provision of after-sales maintenance services of medical devices is a sensitive, a critical aspect of the healthcare industry, given the importance it bears on the healthcare industry and the patient's health and safety. The key features of the medical device sector are marked by stringent regulatory requirements, technical complexity, and the need for consistent performance throughout the device's life cycle. One should also add to this the EOM's interests in preserving its intellectual property rights, its interest for further development in the R&D sector, as well as the strict obligations arising from the MDR, consisting inter alia, in the establishment and maintenance of a post-market surveillance system to monitor the performance of their devices. Now, from a competition law standpoint, a constant source of tension is therefore caused in case an OEM of medical devices is dominant on the aftermarkets of maintenance services and spare parts. Given the high technical complexity, along with the relatively low standardization in the sector, OEMs are most likely to dominate the downstream market of maintenance services for their primary product. Against this background now, assuming that an OEM of medical devices is dominant or even a monopoly in the secondary market of services and spare parts for such a product, the following question arises. Does an OEM's refusal to supply spare parts and maintenance services constitute an abuse of dominance? The first important step here is to define the market. Our law firm has very recently been involved in a very interesting case pertaining to a complaint brought by an independent service provider against an OEM for hemodialysis machines regarding the refusal of supply of spare parts. In this case, both the Hellenic Competition Commission and the administrative courts applied the classic Pelican-Kyocera test. In particular, the following criteria were assessed. First, whether end customers could make an informed choice, including life cycle pricing. Second, whether end customers are likely to make an informed choice. Third, whether, in case an exploitation of the aftermarket occurred, a sufficient number of customers in the primary market would switch and purchase another manufacturer's product. And fourth, whether such adaptation would take place within a reasonable period of time. What did the Hellenic Competition Commission do? Premised on extensive investigation involving, inter alia, questionnaires addressed to key end customers, who in the case at hand were public hospitals and private clinics, along with other competitors active in the hemodialysis market, the Hellenic Competition Commission came into the following conclusion. All the above criteria were indeed met in the case at hand, entailing thus the definition of a single market as a system consisting in primary and related secondary services and products. In the reported case, of course, of the hemodialysis machines, the sophistication of the end customers played a pivotal role. The same conclusion, which I'm about to elaborate on, was reached by the alternative application of the EFIM test, assuming the existence of two individual markets. It was held that to the extent that the primary and secondary market were closely interlinked, competition in the upstream market could prevent abuses in the downstream market. On the basis of this approach, it was found that the OEM did not hold, in the discussed case, a dominant position in the relevant market, single market, and thus no abuse of dominance could be established in violation of Article 102 TFEU and the corresponding domestic legislation, namely Article 2 of Law 3959 of 2011. Although the Hellenic Competition Commission decision has been partially annulled and is currently remanded for further review, the market definition as such was upheld. It is thus safe, one must admit, to conclude that the well-established test for the aftermarkets as adopted by the European Commission in the printer's case remains nowadays valid and serves as guidance in other, far more complex market industries like the hemodialysis machines industries. It must also be noted that this approach aligns with the European Commission approach on the matter. Indeed, in assessing the hemodialysis market in the context of a merger, the European Commission considered that the supply of the primary equipment encompasses as well the after-sales services. Apart from the market definition now, a key takeaway from the discussed case is the distinction between the refusal to supply spare parts seen as a unilateral act of a non-dominant undertaking as opposed and compared to the same conduct when it is characterized and seen from the perspective of an anti-competitive agreement or concerted practice. In the discussed case, the refusal of supply of spare parts, when seen as the result of a unilateral act of a non-dominant undertaking, raised no concerns from a free competition standpoint. It was confirmed that the refusal to supply spare parts fails within the undertaking's economic freedom. The same holds true in case of a single economic entity when, in cases where the OEM and the companies selling the products are affiliated companies belonging to the same group of companies. However, in case the refusal of supply to the same independent service provider stems from an agreement between independent undertakings, as it is the case of an exclusive distributorship, which we had in the case at hand, then such conduct may be assessed under Article 101 TFEU and the respective domestic provisions, leading us to rather contradictory results. For example, in the discussed case, the refusal to supply stemming from the exclusive distributor of an OEM vis-à-vis the same independent service provider was found abusive and in violation of Article 101 TFEU. The reason was that the refusal was considered as the result of an agreement for the restriction of parallel trade. In particular, the exclusive distributorship agreement included clauses restricting parallel trade from the distributors within the network, aiming thus at the partitioning of the market of the EU member states, including Greece. The Hellenic Competition Commission found that in cases of by-object restrictions, there was no need to assess the effects to the competition. It also found that the same agreement ultimately produced anti-competitive effects to the extent that it hindered or made it particularly difficult for other independent service providers to find alternative sources of supply of the same OEM's products outside the contractually and strictly delineated OEM sources, particularly in the context of public tenders. The Hellenic Competition Commission, in this case, confirmed that the restriction of parallel trade is a hardcore infringement, which means that no effect-based analysis is required. This example confirms the gravity of parallel restrictions in the European Union law. It must be noted that although in principle the efficiency justification is available, it is rarely applied. As a concluding remark now, and going back to the original question posed, it seems that the refusal to supply medical devices in the EU does not present the same particularities as observed in the pharmaceutical sector. It can be argued that the refusal to supply medical devices is subject to the same legal principles that govern other sectors, especially under the light of Article 102 TFEU. While there are fewer cases specific to medical devices, the existing jurisprudence suggests that any refusal by a dominant undertaking must be, what else, carefully justified and proportionate, particularly if the device in question is essential for downstream competition. On the other hand, even a non-dominant undertaking may be held liable when a refusal is considered as the result of a restriction of parallel trade. Thank you very much for your attention.
Thank you, Iris. Thank you. Well, from the medical devices standpoint, I do not see the same rationale in safeguarding an OEM's interest as in the case with pharmaceuticals discussed before. I understand that it could be said that the general criteria may apply. I think that the key takeaway from your presentation is that in the big picture, when it comes to free competition, it's never the individual competitor, like the independent service provider in the case you discussed, that is protected. If anything, it is the competition structure and ultimately the consumers who are the objects of protection. At the same time, both presentations confirm that restrictions on parallel trade are considered traditionally a hardcore violation of competition law.
In this point, I want to make a comment. As regards your previous comment, let's not forget that the draft guidelines on Article 102 TFEU is under consultation as we speak. The Commission seems to shift focus away from the notion of consumer harm, which was the cornerstone of a 2008 guidance paper, and explicitly state now that there is no need to prove consumer harm to find a conduct liable to produce exclusionary effects. In the same vein, the guidelines seem to abandon the distinction between anti-competitive foreclosure, which produce consumer harm, and those who do not.
So we're anticipating the Commission's, the final guidelines on Article 102, and most of all, whether and how the case law of the Court of Justice will be ultimately influenced in the future. Thank you very much for your attention. Now it's time to address any questions that our audience might have.